Frank Pellegrino, former New York City agent for the FBI counterterrorism, is actually testifying at Guantanamo Bay this week about his interrogation of Khalid Sheikh Mohammed in 2007. And Lisa Hajjar wrote a fantastic article today for The Nation. And I just want to read a part of it for you. I'm going to supply it in the description box. How the government secrecy on torture stymied the 9/11 terror prosecution. And I'll read part of it for you. So around 9 p.m. on December 4, 2017, two FBI documents were delivered to the defense teams representing the 5 Guantanamo detainees on trial in the military commissions for their alleged roles in the September 11 terrorist attacks. These documents, which the lawyers have been requesting since 2013, will be the focus of proceedings starting at 9 the following morning. The 11th hour timing of these documents drop is not unusual in this legal system, where the prosecution controls when and what government information, as well as access to witnesses' resources, will be provided to the defense. In the 9/11 case, the pretrial discovery process is exceptionally contentious by any measure. The defendants were held for years and tortured in CIA black sites prior to their transfer to Guantanamo in September of 2006. Most information about the agency's rendition, detention, and interrogation program, although it was terminated years ago, remains a national security secret. Why? I mean, look, at this point, we are now 22 years past the events of September 11th. This is the longest running trial in history, and we haven't even begun. Why? Because the state want to protect their interests by not investigating what we could have had to stop the attacks. That's Israel, Saudi Arabia, NSA, CIA. And then afterwards, which is the cover-up, right? The cover-up involving torturing these people to the point where even if they told the truth, you couldn't believe them because they would say anything under torture. And this is the problem, is that we're allowed to believe that they were or they weren't. We aren't allowed to know. And so they control the information. You control the information, you control history, right? The defense lawyers, all who of whom had top security clearances, spent years filing motions and arguing to gain information about what happened to their clients in CIA custody, and insist that this information must be discoverable, not least because in capital cases where the death penalty is on the table, heightened due process applies. Prosecution disagrees, insisting that this trial is about the defendants' roles in the crimes of 9/11 and that what happened to them afterwards has little bearing on their involvement in the events. No, all right? If you had evidence to show that they were involved with the attacks, you wouldn't need to torture them. Now, the Senate Select Committee even wrote in their report, 2010, 11, that the CIA tried to use that as a defense, that, oh, we tortured them to get information about future attacks. Well, you already had information. You didn't need to torture. That's what the Senate Select Committee report on intelligence came to a conclusion. Daniel Jones, right? The report, go watch it. It's very good. But nevertheless, nothing gleaned from torture stopped any attacks. And might I add, this is also a cover for what information the NSA had regarding the wiretapping of the cell phones of satellite phones of bin Laden and Al-Qaeda in the mid-90s, as well as the Yemen hub. And not to mention, the foreign intelligence rings of Saudi Arabia working with the CIA inside the United States in the year 2000, 2001, regarding Khalid al-Mihdhar and Nawaf al-Hazmi, and of course, the largest foreign intelligence ring in history, which was the Israeli art student ring and the moving companies that they were using to spy on not just the 9/11 hijackers, which they were living nearby, but also the FBI, the DEA, and other government institutions. You don't hear about that anymore, do you? John Miller did a report on 2020. Salon did an excellent report on the moving and art student companies and art student ring. But that was it. You don't hear of it anymore. Currently, I'm probably the only person to actually keep that up to date because I'm doing a Gerald Shea memorandum video series where we read along the memorandum. Gerald Shea's a lawyer, retired corporate lawyer out of San Obispo, California, who compiled the arrest reports of the Israelis all throughout the Southwest and Northeast, and used the DEA report, which was compiled about these Israeli art students going to the homes and businesses of agents and employees of government institutions. So, what did they have? Could they have stopped the 9/11 attacks? Well, we don't know what they had. Maybe they didn't have nothing. Maybe they had something. But we don't know if you guys cover up for them. And why? So, two FBI documents delivered that December night provide a glimpse of how the government has strategized in building its case against 9/11/5. The documents pertain to the so-called clean team process, in which the FBI agents were tasked to elicit statements untainted by torture after the men were transferred to Guantanamo. The defense teams finally get these documents because Walter Ruiz, the lead lawyer for the team representing Mustafa al-Sawi, had pressed the judge, Army Colonel James Pohl, to calendar a hearing on whether the military commission is an appropriate venue to try his client, which is true, should have been tried at the Southern District of New York. It's where the main crimes happened. This personal jurisdiction challenge forced the prosecution to provide the defense with information about the FBI's role in relation to the CIA torture program, because statements made to the FBI are an important element of the government's case. That week in December was the 26th round of the pretrial hearings in the 9/11 case, since the 5 defendants were arraigned in May of 2012. The case actually began years ago early, when the same men were arraigned in June of 2008. The Pentagon had pushed to start their trial while George Bush was still in office, because his administration had created the Guantanamo detention facility and the military commissions, as well as the CIA's detention interrogation program. During the 2008 arraignment, the most valuable detainee at Guantanamo, Khalid Sheikh Mohammed, who was accused of being the key planner of the 9/11 plot, rejected his military lawyer. He told the judge that he welcomed the death sentence. That is what I wish, to be martyred. Several of the other brothers, as they referred to each other, followed suit. Apparently, the suicide by military commission strategy had not been anticipated by the government. It foiled the plan to make the 9/11 trial a showcase for expeditious American justice. During Bush's lame duck period following the 2008 election that Barack Obama had won, the case was stayed. In November 2009, the Obama administration Attorney General Eric Holder announced that these 5 men would be transferred from Guantanamo to face trial on terrorism charges in the federal court in Lower Manhattan, close to the scene of crime. Why didn't? The plan was derailed within weeks as a result of domestic political opposition. In the following year, Congress passed legislation prohibiting the transfer of any Guantanamo detainee in the United States. Ask yourself why. What's the real reason? Is it because they don't have evidence against them without torture? Or did they have evidence and they tortured them anyway, and now they can't use that evidence because they screwed up? You tell me. I'll link the article in the description, actually. And Lisa Hajjar wrote about the FBI's cover-up regarding that they attempted to persuade, to intimidate non-attorney members of the 9/11/5 defense teams to inform on their colleagues. And Lisa Hajjar wrote this article back in 2014 called "The Long Shadow of the CIA at Guantanamo." And what I'll do is I'll also link that in the bottom of the description. And basically, what she writes is that the FBI and the Justice Department were carrying water for the CIA in the spring of 2014. That it was revealed that FBI agents had attempted to persuade or intimidate several non-attorney members of the 9/11/5 defense teams to inform on their colleagues. In fact, the motivation for this spy operation was a suspicion that people might be mishandling classified information, and that the operation was exposed when a linguist on the Ramzi bin al-Shibh team disregarded the non-disclosure instructions and told his colleagues about what was going on. And because the investigation was closed, one of the lawyers urged Judge Pohl to deny the defense motions for further hearings in which the FBI agents will be called to explain who had ordered the investigation in the first place and why. And this is the FBI's operation is just the latest in a string of spying incidents. The first was the revelation that government agents were reviewing legal mail between lawyers and their clients. The second was the revelation that the CIA was remote controlling the courtroom itself, by the way, on January 28, 2013, Sheikh Mohammed's former attorney, David Nevin, was addressing the scheduling of a motion pertaining to secret prisons. And as soon as he said the word secret, flashing red lights and white noise filled the courtroom. The alarm was triggered, not by the judge or the court security officer, but someone off-site, which is who's controlling. So that it makes you wonder. Here you have the Pentagon military in the courtroom, and then you have somebody else watching them. It's the CIA. So, I mean, really, at this point, it's just basically we're either going to learn little to next to nothing or nothing at all. They don't want us to know anything. And that is because that's exactly where we are, in a state of paralysis, as I would say in the past. And because of that, we can't act. We can't do nothing. We can believe that they're guilty or not, but we don't know it. And if they signed the latest agreement that the Biden administration offered, that they would take the death penalty off the table, and if they plead guilty across the board for 9/11, then that would mean that whatever information the government has is classified for the next 30 to 40 years, maybe even longer. And that we'll never know what they didn't have. That's most important. We won't know what they didn't have. That's exactly what I want to know. I want to know what they don't have. Because then we could start putting in the missing pieces to the puzzle. All right. And if there's any updates this week, which I think there's going to be, of course, you'll hear from me without bias, without prejudice. Have a good day, everybody.